Hi, I'm Nicole Spickard, and today I will be talking about Saxe versus the State College Area School District. The case took place in 1999 in State College, Pennsylvania, when Dr. David Warren Saxe, who is a member of the Pennsylvania State Board of Education, as well as a professor at Penn State and a former member of the school board for State College Area School District, was approached by a group of parents to represent two students at State College Area High School in a case concerning First Amendment rights. Due to the implementation of the school district's anti-harassment policy, these two students were unable to voice their opinions about homosexuality in regard to their religious beliefs without being reprimanded. The students felt as though, while their peers and teachers may not agree with their beliefs and opinions, their right to freedom of speech and freedom to exercise their religious beliefs are and should be protected by the First Amendment, thus bypassing the anti-harassment policy. The anti-harassment policy in question stated that any unwelcome verbal, written, or physical conduct which offends, denigrates, or belittles an individual because of race, religion, color, national origin, gender, sexual orientation, disability, or other personal characteristics should be prohibited. As for the case itself, it really took off during a town hall meeting arranged by the school board where Dr. Saxe had requested to speak on behalf of the two students regarding the matter. However, he was denied the chance to state his case out of bias by the school board members. As a result of this and the school board choosing not to revise the anti-harassment policy, the American Family Association stepped in and offered to represent Dr. Saxe and the two student plaintiffs. After this, they filed a complaint on October 4, 1999. Upon reviewing the case, the district court in Williamsport, Pennsylvania, sided with the school board, stating that the policy was unconstitutional. The plaintiffs then proceeded to file an appeal to the Third Circuit Court of Appeals in Philadelphia. The panel hearing the case consisted of 3 judges, and in a shocking plot twist, the panel unanimously decided that the anti-harassment policy in question did in fact violate the First Amendment and was ruled unconstitutional. The court stated that the policy's broad wording prohibited too much in the way of speech that basically anything could be deemed offensive depending on how people took it. Thus, this violated the First Amendment. The court reasoned that the policy prohibits a substantial amount of speech that is neither vulgar within the meaning of the Fraser Standard nor school-sponsored within the meaning of the Hazelwood Standard, and that it could even prohibit speech that harasses someone based on clothing, physical appearance, social skills, peer group, intellect, educational program, hobbies, or values. Furthermore, the panel stated that the policy interfered with the First Amendment's right to exercise one's religious belief and freedom of speech. This case applies to communications for incredibly obvious reasons. The First Amendment enables us to speak our minds freely without legal punishment. In communications, freedom of speech is paramount in that we can voice our opinions and state facts, theories, etc. without persecution. While it's hard to imagine life in any other way, there are countries today such as North Korea and countries in the Middle East that limit speech on such extreme levels that not only is it not tolerated by their peers, but in some instances, speaking your mind can be a death sentence. While the case of Saxe versus State College is not an extreme case in our society's regards, its significance in the First Amendment rights is a crucial facet in the communications realm. Take the current presidential election, for example. Candidates have brought up religion on numerous occasions, and while not everyone agrees with their opinions, it's their First Amendment right to be able to express themselves freely without living in fear. The significance of this case consists of a multitude of reasons. First off, our anti-harassment policies are legitimate and necessary implementations within school districts and otherwise, and the dialogue of the policy must be specific in nature and not broad in the way that anything could be deemed offensive, and that the school government cannot ban speech that is protected by the First Amendment, as we saw here with this case. The First Amendment was written in order to protect the voices and minds of the people, thus enabling them to speak freely, practice religion freely, petition the government, assemble, and gather information on their own accord. So for the Third Circuit Court to overturn the previous ruling by the district court in favor of the plaintiffs is a landmark decision for the fight to protect our rights as United States citizens. While we as a society won't always agree with one another, it's a privilege to be able to live in a country where differing opinions and beliefs are not only acceptable but encouraged. And having the First Amendment and the Bill of Rights protecting those rights should be appreciated on all counts. And that is the end of my speech. Thanks.